Good morning, everyone. Welcome to the May
Recording in
15th,
progress.
2025 Committee on Family Court meeting. Welcome to those who are also joining us online today. We have a quorum, so I'll go ahead and call the meeting to order. David, you have some housekeeping matters?
Yes, thank you, Judge. In the initial meeting email, you should have received a copy of the statewide memo regarding the Families in Transition program. When you have a chance, please do read that thoroughly. If you have any questions or if maybe you misplaced the email and would like an additional copy, please email us at cofc-staff@courts.az.gov. We'd be happy to get you another copy. For those members who are here in person, you will notice there's a phone apparatus in front of you. Please, when you want to speak, you want to look for the little button with the silhouette on it. Click on that. The light will turn green. That means that we can hear you. And when you stop talking, please remember to hit that again. Sometimes when there's two microphones that are turned on next to each other, we'll get feedback. There are beverages here in the room. Also, restrooms are located directly out of the main doors. You'll just go to the hallway just to the left of the elevators, and there'll be a little cove on the right. That's where the restrooms are at. In the event of a fire or an emergency, please follow AOC staff. That's myself and Chelsea. We're going to exit out of those same giant doors there. We'll go into the main foyer, then we will turn right and walk out of the building. If you are using your laptop to get a better view of an item projected on the screen, please remember to lower your laptop speaker volume. Again, we'll get feedback with these microphones. For those members and guests who are attending virtually, please make sure that you are in a quiet area. Please remember to mute your computer or phone when you are not speaking. If attending by phone, please do not place the meeting on hold. Simply hang up and rejoin when you can. Should we experience any feedback, please check to make sure that your phone or computer microphone is muted. Additionally, lowering the volume on your speakerphone or computer when speaking will help. Members, you'll be able to mute, unmute, turn your cameras on and off. If you want to speak, please do raise your hand to indicate to the chair that you wish to speak on a matter. And when you do, please be clear on any action items that we ask for a vote on. Our call to the public portion of the agenda provides an opportunity for the general public to provide input on the topics listed on the agenda. Please keep in mind that while this committee welcomes input and suggestions on how to improve the court process, this committee is not a court of appeals and does not have authority to change any rulings in your family law case. Each person who has requested to provide input will be allotted 3 minutes. After the 3 minutes have expired, members of the committee may ask clarifying questions. However, the members are not obligated to answer questions from the speaker. For speakers, if you're attending here in person, when your name is announced, you may speak at the podium. If you are attending by computer, when your name is announced, you'll be given permission to unmute yourself if you wish and turn on your camera. If you are attending by phone, when your name is announced, you'll be given permission to unmute yourself. Then you'll need to dial *6. Those wishing to provide input about agenda items during the call to the public or afterwards may either send his or her name, organization, if any, and the subject to be addressed in an email to cofc-staff@courts.az.gov in advance of a meeting or after, or you can complete the form near the sign-in sheet here in the room and hand it to staff. Thank you, Judge.
Thanks, David. And for those in the room, the setup today basically means if you're not within 3 seats of me, I'm blind. You're blind to me. So I know it is not a timid group and people are willing to speak up, but just speak up extra loud today or raise your hand or something as well. It's not intentional if I don't call on you. It's just I don't see you. So with that being said, it is the time for call to the public. I know we had a couple of people reach out to us before today wanting to speak. Don't know if Miss Betts is online.
Yes, Miss Betts. Thank you, Ms. Betts. And yeah, if you're online here and you or may I call your name, if you could just raise your hand to help identify, I appreciate it. There's a lot of people in the waiting room.
Recording in
Ms.
progress.
Betts, are you there?
Hello?
Hi, Ms. Betts. Yeah, we can hear you. Go ahead.
Okay, great. Thank
And Ms. Betts, your time has been started. I just want to let everyone know our call of the audience is 3 minutes per speaker. So and if there's any follow-up questions of committee members, you may follow up with any public member. But Ms. Betts, with that being said, you may proceed when you're ready.
protection by abusers.
That's Ms. Betts, you're at your 3 minutes if you want to conclude your thoughts. Thank you, Ms.
Recording in progress.
Okay, can you hear me? Can you hear me?
Yes, we can hear you.
Okay. Hi there, my name is Kendra Durfield. I'm commenting today because our family court system really can and must do better for our children. I recently came across some information on Tucson's domestic violence court that's led by Judge Millian. And I believe it offers a model that family court could learn from. In that criminal court setting, professionals, including the attorneys, the court staff, and judges, they all receive domestic violence specific training, and then they work within a coordinated structure. The court connects the victim survivors to services and holds offenders accountable with evidence-based treatment, not anger management, which we know is ineffective for abusers. This kind of focused, informed system shows what could be possible when domestic violence and child safety is taken seriously. But in family court, the story is very different. They're the professionals making life-altering decisions, the BIAs, the CAAs, the judges, the attorneys, the TIs. They often have little, if any, training on domestic violence, child abuse, trauma, or even just basic child development. As a result, they're often missing signs of coercive control, post-separation abuse, and trauma responses in children. This really is a systemic failure, and our children are the ones that are paying the price. The triage system that's currently being piloted is a step in the right direction. But it must be available to all families, not just those that are representing themselves. Also, I just really want to say that if a case is flagged for the highest track, the red track, then every professional involved must be thoroughly trained on a wide array of things that families experience. We expect our teachers and many other professionals to be trained before they can work with children in a classroom and other places with children. Shouldn't we expect the same or more from our professionals that are making decisions about a child's safety and their future? Also, I just want to urge you to understand that what helps a child recover and thrive is autonomy. Research shows that children exposed to abuse and coercive control begin to heal when they are heard, when they are given choices in their therapy and daily life, and when they are supported in rebuilding a sense of personal power. When we restore their autonomy, their mental health improves. When we ignore their autonomy, their trauma deepens. Again, if I urge you to take steps towards implementing specialized training for all family court professionals. Every person that touches the case needs to be thoroughly trained. Until then,
And if you're right,
I'm pretty much finished here. Just
want to wrap up a final thought.
until we're training, until this training happens, child safety is simply left to the hope that a judge might recognize that a child's in danger. Thank you for allowing me the chance to speak today.
Thank you, Ms. Durfield. We have no one else in person. No one else has submitted a request for the call to the audience. With that, we'll move on to the next agenda item. I also just want to let those who are online know as well, there is a listening session, which is more informal and allows for additional time and feedback that is being conducted before these meetings at 8:30 in the courthouse. If you're interested in that, there should be a sign-up sheet that will be made available on the website for the committee that you can ask for additional time with that listening session. Next item on the agenda is approval of the February 13th, 2025 minutes. The minutes themselves begin on page 4 of your packet.
I would move to approve.
Okay. Jenny Gatto moves to approve the February 13th minutes.
Second.
Second from Aaron Richardson. Any further discussion? Is there any opposition to the motion? Hearing none, the motion is approved. We have a second set of minutes for our special ad hoc meeting that was done on March 6th of 2025. Do you have a motion regarding those minutes? They begin on page 9 of the materials. Jenny Gatto moves to approve.
Second.
Thank you. Aaron Richardson seconds. Any further discussion? Hearing none. Any opposition to the motion? Hearing none, motion carries.
Ms. Turner, are you raising your hand because you wish to speak to the committee?
That was correct, but I don't know. I did submit something prior to the meeting starting, about 25 minutes prior, but it may not have been received. And so I was just trying to get an opportunity to speak, but it sounds like you guys have already moved on. So I don't really want to interrupt your sequence of things, but I did just want to speak briefly if that was an option.
Ms. Turner, some of us were in another meeting, so we may not have seen the request, but we have time set aside for public comment. So if you wish to speak at this time, you can have 3 minutes like the other public members did.
I would really appreciate that. Thank you very much.
You may
I
proceed.
went through,
Ready.
sure. So I went through my own case in 2016. I don't think that it's, the right forum to speak on it. However, due to my case, I just, I really took an interest in the family law, and I went back and I learned all the laws, the statutes, the courtroom procedures, the judicial code of conduct. And I truly believe that when the system is ran the way that it's designed to run, it, for the most part, has a fair outcome every single time. I believe that the problem is the people running the system, and that's not everybody. That's just, specific judges who are running it the way that they want it to be ran and making their own laws. And I have found that there's no real true system put in place to hold judges accountable. I know you had the judicial committee and everything, but those are other judges who aren't really willing to call out another judge or, sacrifice their name and reputations in order to do the right thing. And I encourage you, I see you doing these mock trials and all these different things to improve the system. The system's fine when it's ran the way it should be. The problem is until there's a system put into place where judges know they're going to be held accountable for their actions and their behaviors that are illegal, corrupt, or dishonest, nothing is ever going to really change in the family court system, truly. You can change around the way it's ran, who runs it, who makes decisions. But until you're really willing to step in and say, okay, here's what's going to happen and how we're going to do it, and this is what's going to hold them accountable to their behavior, it's not going to effectively improve. It just won't. And so my question is what are you guys doing to truly address it? Because I listen to these meetings every single time. And what I find is that there's never, ever anything that states what you're doing to hold the judges accountable in a different forum outside of just the judicial committee, on ethics and improvement. Because every time I hear these people talk, these litigants talk, I can hear their hearts breaking, and they're complaining about the injustice. They're complaining about the way their case was handled. And they're probably right. But if that's the case of what you're hearing time and time and time again, which is all I hear when I'm on these meetings, wouldn't you think that it would be the time then maybe to address the system that's in place to allow a proper process and allow a fair outcome to come about when judges act outside their position and the oath that they take to uphold the Constitution and honor the laws and the rights? Maybe that's the avenue that the committee should be looking at, improving prior to these mock trials and everything, to just give an opportunity for something else to maybe improve the whole system as a whole. Thank you.
Thank you, Ms. Turner. We have time for 2 additional persons. We have 2 more individuals raising their hands.
Yes, Judge. Monabeth Kepler. Sorry if I mispronounced your name.
That's okay. Yes. Hello. Thank you so much. My name is Monabeth Kapler, and I appreciate the opportunity to speak to you today. I'm the mother of 2 children that are in the family court system here in Maricopa County. I'm here today to ask for accountability and to plead for reform in how Arizona's family courts respond to protective parents. My son's father has admitted in writing and to professionals that he is attracted to children. My son then reported abuse to his older sister last year on Mother's Day. When I learned this, I did what any responsible, loving mother would do. I took it seriously and made good faith reports in the hope that my child would be protected. Instead, after it was investigated, I was blamed by my family court judge of coaching my child. There was no evidence of this, and my judge found it as fact based on my ex-husband's testimony alone. I was treated as if I were the problem. Despite the seriousness of these admissions by the father, the court-appointed advisor, RCAA, failed to advocate for my son's safety. The report did not reflect gravity of his risk, and instead I was portrayed as high conflict or overreacting. As a result, the court awarded this father 50-50 custody, and our child has been with him for the last 4 years. Let me repeat that. A man who admitted in writing, on a voice memo, and to a professional that he was attracted to children was given equal parenting time with a vulnerable child. He was not asked to receive an evaluation. Instead, he was just automatically given 50-50 custody. I followed every court order. I've remained respectful. I've done everything the court has asked of me, and still I'm being punished for trying to protect my son. My children were even placed on opposite custody schedules. Statistically, less than 1% of child sexual abuse cases are prosecuted, not because the abuse isn't real or not substantiated, but because systems like this often fail to believe or act in time. The court claims to act in the best interest of the child, but how is it acting in my children's best interest, who are often left unprotected? 80% of individuals in family court in our state are self-represented. I, for one, have not been able to afford the same caliber of attorney as my ex-husband's, and I'm being ordered to do things I can't even afford, and my children have now been taken from me. I am begging this committee to review how these cases are handled, especially when a protective parent brings forward serious documented concerns. We need oversight, we need trauma-informed decision makers, and we need to stop treating protective parents like they are enemies of the court. Please help protect our children.
Thank you so much. And last, we have Ms. Sherwin.
Can you hear me?
We can hear you, Ms. Sherwin. Yes.
Hi. I've been on watch courts for 34 years this year. And I believe that a divorce or a custody battle between parents is it's a renegotiation of the marriage contract, and which includes timeshare, division of property, and it's a business matter, and that can be handled in the civil courts. We don't need divorce courts. If you break court orders, if you severely neglect, batter, rape, or kill your ex and or the children, that's a criminal matter. It should be handled in the criminal courts. What the family law courts do is for the upper echelon, they find out how much money you get, and then it's all divvied up between third-party appointees that parents are forced into contracts with by the court, and third-party appointees, lawyers, agencies, psychological evaluators, and these are all people that make a killing. And if a divorce or a custody battle because most people settle their problems during a divorce. But when a case goes on, a post-judgment case goes on and on and on for years, being churned by lawyers and third-party appointees, you can, and they describe it as a bitter custody battle. What it is an abuse case. Someone is being abused, and you all are ignoring it. There is automatic suspicion of any protective parent that goes into the court and tells you about the disclosures of their children, of rape, of a battery, of severe neglect. It is you're also well practiced in your private AFCC meetings with each
Ms.
other.
Sherwin,
Yes.
you're at your 3 minutes if you want to conclude your thoughts.
Yes. You know what? You've all been trained because the incentives are too great. The money is the money that these courts have stolen from generations of families it's scandalous, and it has to end.
Thank you, Ms. Sherwin. Next up on the agenda is we have a legislative update. I don't know if Liana Garcia is with us. Okay.
Hello. Hello.
Hi, Liana. How are you?
I'm doing okay. How are you guys?
We're doing well. Thank you. For committee members, the legislative update materials begin on page 13 of the materials if you're following along. Liana, when you're ready.
Yeah. Thanks for having me. A little update from where we're at in the legislative session. Most of the bills that are moving through the system are pretty cooked. They've either needed to go through a committee to stay in the works or have voted on and been vetoed. So in your materials, you'll see that there's only one bill there, and that was House Bill 2256, that would have prohibited a court from ordering a party in a legal decision-making or parenting time proceeding to pay for therapeutic intervention without the party's consent. It also required expert testimony on therapeutic intervention or related issues to be supported by clinical experience and professional guidelines. So basically what it did is it sort of used language that are in our rules of evidence and applied those to any professional that was investigating, evaluating, submitting a report or recommendation to the court pursuant to 25405 or 25406 to meet the standards that we use for an expert that testifies at trial. So that bill did make it through the House and through the Senate, and it was just vetoed by the governor either yesterday or the day before. I can't remember. They all sort of run together. But that bill was vetoed, so it will not go into effect. And that was sort of the oh no, there was one other bill related to family court, and that was the neutral exchange location bill, 2432, parenting time neutral exchange location. That's a bill that a lot of you on this committee helped work on, and it specifies that law enforcement agencies are to establish an exchange location for folks that need that in their custody cases, and those locations need to be accessible 24/7 and have lighting and signage and video surveillance. So that bill did get passed and it got signed. So that will go into effect 90 days from the end of the legislative session. And as to when that will be, I am not certain. They need to negotiate a state budget between the legislature and the governor's office. And from what I understand, those negotiations are not very far down the road. So we will probably be in session well into June. Hopefully they will get some kind of a budget enacted before the end of June, because that's the end of the fiscal year. So that's where we're at in session. The other piece of information that I provided for you in your materials is I think I sent you the,
Yes, it's on
oh
page
yeah, the
18.
joint, okay, there you go. Joint Legislative Ad Hoc Committee on Family Court Orders was established by the legislature for the purpose of taking public comment and expert testimony on issues related to family court proceedings and the legislation that could potentially be enacted. And that committee has met twice. Both of those sessions were very focused on testimony of the people that have been involved in the family court system. Many of the same folks that you've been hearing comments from at your meetings, basically with the complaints about, the courts needing more training, judges and court staff needing more training in the areas of domestic violence and the areas of sort of the thought that there is a pervasive problem with respect to requiring folks to pay for a lot of the therapeutic interventions and whatnot out of pocket without any funding or assistance. That's been sort of the main focus of the testimony. There has been a lot of testimony too from folks that are involved with DCS proceedings that really aren't family court related, but I think the grievances kind of get rolled up together among those folks. So that's sort of been the testimony to date. They also have heard testimony from the Board of Behavioral Health Examiners and Commission on Judicial Conduct. April Elliott, the director of the Commission on Judicial Conduct, and one of our public members gave committee testimony, and they talked about what things the commission does and does not have jurisdiction to decide. And they've also talked about how many complaints they receive and what types of complaints and how quickly they process the complaints, that kind of thing. So from what I understand, there will probably be a series of more of these meetings designed to get ideas for legislators to enact legislation around family law to address a lot of these concerns. So to that end, I can provide information to you about what that process looks like, but I have not been very involved in it. I've touched base with the staff and with the chairs of that committee and asked to be on the agenda so that family court folks, not me personally, but judges and subject matter experts can provide the background information that I think is lacking. A lot of our legislators don't really have a lot of knowledge and experience in this area. So there's some education that needs to happen both ways. I think the judges in the court community can be educated too about what the legislative process looks like and how they come up with bills. And hopefully we can all get on the same page, because I do know there will be legislation on this issue in sessions to come. So it's not an issue that's going to go away, as you folks well know. And I've been sort of trying to gather ideas, because there are a lot of improvements we can make in the statutes. So I've been trying to gather ideas that we can work on that will improve our family court system, that are implementable. And I think there are lots of good ideas percolating out there, along with some that are not great, but that's part of the process too. So that's where we stand with working with the legislature on that issue. With that, I'll take any questions that folks might have.
Thanks, Liana. Any questions in the room for Liana? Not seeing any. Any online questions of committee members for Leanna? Not seeing any also. So Leanna, just to be clear, there was a presentation previously about a lot of bills about family courts. All the other bills at this point in time are dead to the best of your understanding.
Yes, yeah, all of the bills that had been kind of working through the system, none of them made it through other than the bill about neutral exchange locations. That's the only bill that has made it through the system this session. They'll probably be back in some form next session because these legislators are motivated to make some changes. So I do expect them to come back next year, but for this year, they're not moving forward.
Thank you. And not seeing any additional questions from committee members. Leanna, thanks again for the update and all your services on behalf of the court. We appreciate it.
You bet. Thank you, Judge.
Just because we may have House Bill 2432 in front of us, it starts on page 15 of the materials. I know Judge Fisk was involved in the process, and sorry, Judge Fisk, to put you on the spot, but are there any procedural rules? Are there any policies and procedures, either at a statewide or county level, that the judiciary should be looking at with this bill going to be implemented probably late summer, early fall?
When you say procedural rules, are you referring to the family rules?
Sure.
I don't think so. I think it's more, what I will say is that I'm going to reach out. The impetus for the bill was an email that I received from the county attorney's office.
Mhm.
So I was going to reach out with them and share with them that this is what came of it and ask if they had an interest in helping us publicize this. And then in addition to that, working with CIDVIC and in particular, the law enforcement agencies on CIDVIC to see if they could champion kind of, because it is not mandatory, but
Right.
champion law enforcement agencies setting up neutral safe exchange locations. What I will say is in the bill, a court has to indicate if they are ordering the use of a safe exchange location, not to be confused with a neutral safe exchange location. Those are two different things. And so there may be some wording that we as judges should put in our parenting plans that reflect compliance with the statute and using the term safe exchange location, which is any location the court orders, any location the parties agree to, or a neutral safe exchange location.
Yeah. And has there been preliminary thought to how we make sure judges and parties are aware of where these specific locations are?
Well, the bill itself has written into it a requirement that the sheriff's offices have a page. So that's a matter of education. I guess we might ask the Bar Foundation to update their webpage, but unfortunately at this time, there's no, those sites don't exist.
Right.
But I think that within the next year, we could make a coordinated effort to make sure that that information gets out to the public. The first part is getting law enforcement agencies to decide to do this voluntary program.
Sure. Yes, Jenny. Yeah, no.
Once those sites are set up, is it not a violation of an order of protection for the parents to show up at that exchange site for an exchange?
You mean if there is an order of protection between the parties?
Correct.
Yeah, well, yes and no, I guess it depends on the terms of the order of protection. Some have things in them that I'm not going to opine on whether or not they're appropriate, but I'm just saying in many cases, if there is an order of protection, it would be a problem for two parties, one protected person and the person who's the defendant on the order of protection to be at the same location.
And I guess that's one of my concerns. We call it a safe exchange location, but you still can't, if there's an order of protection between the parents, you still can't have them both there at that exchange site.
And it in no way modifies an order of protection.
Okay.
But the parties could stipulate to a modification of an order of protection if they thought it was appropriate. And I'm not saying it is always appropriate. Or the court, when it entered the order, might include terms Again, I'm not opining on whether that's appropriate, but I've seen it done.
And that might be helpful from an education standpoint, certainly from the lawyer's perspective, if we can speak with our clients and perhaps suggest a modification to permit that exchange location to be okay. Because otherwise you're trying to figure out third parties to go to those sites anyway. So, okay, thank you.
Additional discussion on this point? Thank you. Judge Fisk, thanks for your efforts on that. Seems to be a workable statute and a benefit for families that need those services. The next item on the agenda is a discussion of the child support guidelines review discussion. Materials start on page 19 of the materials. As you all know, this committee, one of its tasks is to do a quadrennial review of both the spousal maintenance guidelines and the child support guidelines. We are at a time for one of the quadrennial reviews of the child support guidelines. The intention is, I believe, that the Chief Justice will form the committee later this year. In the fall, there was discussion amongst staff about whether or not the committee should be convened early, or it was raised by one of the members of the prior review committees, was suggesting there were carryover issues that were discussed 4 years ago that maybe some additional time would be needed to review, in addition to any of the technical review, which is the primary focus of this year's review. So what we have included in your material starting on page 20 are those carryover issues that may still be appropriate to review. Legislation may have passed, other things may have happened that do not merit as much discussion. But I was interested in discussion amongst the committee if you believe that any of these issues is a red button issue that definitely needs to be discussed, or any issue that you believe needs some additional time, such that maybe the subcommittee should be formed earlier to allow them time to work through some of these issues before the technical data becomes available. So. We'll give everyone a minute or two, look over the list. It's a long list of items that were carried over. Ms. Jenny.
I'll just point out, I know there's a section there about counting hours to include the hours that children are in school. It would be, I think, very much a challenge and opening a really tough door if you start counting hours and then half days of school and holidays. We already have people that count days, and if you start narrowing it to hours, I think we're in for a host of problems. So that's my 2 cents.
Judge Ainley, online?
Yes, I was wondering, is this list, I'm sorry, I wasn't very clear. Is this list a list that we're to determine whether our recommendations?
There was a report prepared 4 years ago when the child support guidelines were last reviewed. These were other topics that were discussed or recommendations for future considerations from the prior subcommittee. Does that help?
I would not like to delay our recommendations that have been determined so far to open up new ones. If we want to look into those at another time, but I think the issues we worked on were pressing enough that they need to move forward. That's my 2 cents.
Okay, thank you.
Greg, can I ask?
Yes.
You're not suggesting we delay the spousal maintenance guideline?
We are not asking to delay spousal maintenance. This is the separate track
Okay.
for child support only, and these are the child support guidelines.
And the two are not interrelated?
Two are not interrelated.
Okay, just making sure.
Yeah, absolutely.
I have a question. So are you asking, sorry.
Yes, Patricia, thank you.
if there should be some meetings before the meetings or meetings before the subcommittee formation or something like that. The issue that pops out to me is the tax allocation application of the self-support reserve test, where a parent who does not contribute, maybe where they actually get a windfall from the tax return, if the tax kind of the benefit exceeds what they've contributed for child support. So I think that deserves a little bit of examination, whether before or during.
And I'm not sure the subcommittee would have to be formed before it could meet. So I'm not sure we can have pre-meetings, but we might be able to get the subcommittee formed a little earlier to address some of those issues and have enough time to address those. If you have any other on this topic, because again, it will be appointed, the subcommittee will be appointed in the fall. It does come from the Chief Justice. So if you have an interest in serving on the subcommittee or know of someone who would be good serving on the subcommittee, please let David or Chelsea know. We can include those recommendations when it goes up to the Chief. Yes, and we are especially looking for someone who might be willing to chair that subcommittee. Not looking at anyone right now. So, but best of luck if anyone is willing to take on that duty. Again, it is not the wholesale rewrite of the child support guidelines as it was most recently. It is a more technical revision with maybe a few substantive issues as well. Mr. Fine with this? Okay. Next on the agenda, we have Jeff Fine, now AOC staff, former clerk of Maricopa County Superior Court, and maybe Chris Driscoll updating us on AZ Cares.
Can you hear and see me now?
We can both hear and see you. Good morning, Jeff.
Good morning, everyone. My name is Jeff Fine, and please excuse my less than formal appearance this morning. I'm actually on leave, and I wanted to tune in for this meeting. I didn't want to miss it, but I'm off for the next 2 days. My youngest daughter is getting married tomorrow, so I'm at the venue, all hands on deck for our baby girl, the fourth of 4 children to be married in 2 years. So it's a very special time for our family. It's an honor to be here. I am joined today by Chris Driscoll, who I believe is in the room. I believe we are scheduled to provide an update on the AZ Cares platform. I think we had intended to introduce ourselves and then provide an update each on 1 or 2 items. If you don't mind, and if Chris is there, I'll go ahead and I would like for Chris to be able to introduce himself and then talk about the items he would like to update you on, and then I'll do the same in just a moment. And by the way, I can't speak highly enough of Chris. He has a significant background in helping to connect business processes in the courts to technology solutions. We were so fortunate to get him into his new role, helping us navigate the waters of the AZ Cares platform. So if it's okay, I'll turn it over to Chris.
And I apologize. We thought Chris was online, but he is not online. So, and he is not in the room, Jeff. So
Oh, he isn't.
We are about 15 minutes early. So,
okay. He may be joining us in a moment then. And if you give me 10 seconds, I will text him and ask him to join us. Okay. I just let him know. Hopefully he'll join. And all right, hope my headset's working fine here, and I got a fly around me. So again, my name is Jeff Fine. I recently joined the AOC team. Some of you may know me. I'm sure I've worked with many of you. I can't see who all is in the room. My background is about 28 years in the courts, about 15 years in the municipal courts as a municipal court administrator, and then also as a hearing officer in the municipal courts. This was followed by a 4-year term as a justice of the peace. And then I became the justice court administrator for Maricopa County. Did that for 5 years before running and succeeding in the election to be the clerk of the Arizona Superior Court for Maricopa County. My new role at AOC is kind of multifaceted. It touches the Family Court Committee a little bit in a couple different ways. I'm the DES liaison for the Arizona Judicial Branch. Number one topic there is AZ Cares. Also working with others and DCS and interfacing with DCS on some topics related to family court. My item to share with you today, and Chris will talk about some of the stats and a few other general items associated with AZ Cares. What I would just like to brief you on is one item. It is the platform known as Atlas. Atlas preceded AZ Cares as the platform that clerks around the state use to help manage issues of child support and spousal maintenance. It is the tool that clerk staff around the state use when they're interacting with customers and providing assistance and helping them solve problems. As you know, the rollout of AZ Cares last year was a bit problematic, and we are engaging rather robustly. Atlas has been available online to our clerk staff across the state for us, for clerk staff to be able to go look up historical information that may be needed to correct issues from data conversion that was problematic. So in other words, when people are calling with a problem, clerk staff may say, give me a moment, I'm not getting what I need in AZ Cares, I need to go into Atlas and look that information up and see if we can help you. So Atlas, DCSS had not intended to keep it online for too long because the technology is outdated, and to upgrade that technology and make it work for the future beyond June of this year would cost hundreds of thousands of dollars. DCSS has announced that they are going to transition this platform to a new environment where instead of clerks having direct access to that historical information, they will submit a ticket to DCSS, and DCSS will download that data and get it to the clerks. So how might this affect the courts? How might this affect family courts? Well, it's possible that when doing arrears calculations, this type of thing, periodically, not all the time, but periodically, there may be a need to take a deep dive and look back at some historical information. Chris and I, in talking with DCSS, wanted to make sure that number one, the retrieval process has been proven, that it works, that we're going to get what we need. And the second piece is we're going to get it when we need it. We have been assured that that the system is being vetted, this new process, and we've also been advised that there will be the ability for us to elevate cases. So if you have a matter where you have a proceeding that's pending that will require some research in Atlas or require data from Atlas, that we have the ability to elevate that to mitigate any impacts on the court. So that's what I wanted to brief you on. That is the latest large development. I will just say, generally speaking, DCSS has been very responsive. And I had a meeting recently with the deputy director and have learned that they are adding substantial resources so that when the vendor is complete with the fixes that they are responsible for, and they turn the program over to local developers to further enhance it and make it better, there are going to be additional resources added to help move the process along even more quickly to resolve issues moving forward. So those are my items. Have we been joined by Chris yet? I don't know that I see him.
Yes,
there we go.
He is online. He just missed that very glowing comments, Chris, from Jeff about all of your skill sets. So we're welcome to have you with us.
Thanks, and I appreciate you having us here this morning. It's good to update you. As Jeff might have mentioned, I'm Chris Driscoll. I'm a special projects manager with the clerk of the Superior Court here in Maricopa County. And Jeff and I will be tag teaming to take over the roles with Susan Picard retiring and Teresa Barrett and Mike Nims stepping back from their temporary roles here. So we'll be serving as the DCSS 4D and non-4D coordinators here. My updates, I have a couple brief ones. The first one is about the ACAT tool. This is the arrears calculation tool, and version 5 has been live for about a month and a half, 2 months now, and it is going very well after a lot of the issues that were had early on. Maricopa County, between court staff and the clerk of the court, have done over 500 accurate calcs now and sent them out to customers. They have been manually vetting them and reviewing the math before they go out to ensure that they're accurate, and they're estimating about 95% of the ones going out and being completed are completely accurate. So that is a very good step in the right direction. Of those other 5%, which is still much higher than we want it to be, but the good news is there are some actual known issues in there that DCSS is working with the vendor on to get resolved. A fairly common one that we hope to eliminate soon is when there are NSF payments, non-sufficient funds payments in the history of a case that is throwing out the calculations from time to time. But otherwise, it seems to be going very well. And so most of the offices are looking to kind of open those up to the public. Some offices were not allowing new requests to come in for arrears calculations, and we're looking in the very near future expand that and open that up again. Moving on from that on a somewhat related note is the number of tickets and what we're seeing as a way to kind of gauge support and the accuracy of daisy cares in general.
Is that your
feeling
about what you had to do?
100%.
And not to put down being worked and in progress, while April saw 88, and there are 21, I believe, that are still in progress there. Those are pretty static and plateaued
Saying
from what
exactly
we've
what
been
I
seeing
thought
over
I
the
heard.
last several months, but they're also in part pushed up because of a lot of those NSF issues that I mentioned with the ACAT tool. So we do suspect we do assume that those are going to continue to trend down a little bit, but it's still a very complex system. There's always going to be some tickets going on there. But as an example of the efforts of DCSS and working with the vendor on this, even though there were 76 tickets opened in March, they closed out 122 of them, showing significant work on the backlog that was there and closing things out. So those are my two main updates, other than again, emphasizing what Jeff said. Very happy to be involved in all of this. We've been seeing great support and coordination between the vendor, DCSS, AOC, and statewide, both court and clerk's offices. There any questions that anybody has for Jeff or I?
Yeah, thank you, Chris. Any questions in the room? Okay, any questions online from committee members? Not seeing any committee member questions. Jeff and Chris, thank you so much for taking leadership on these issues. Can I just get a sense of the room? Is there a desire for ongoing AZ Care updates at our future meetings in September or forward? I know this was a very hot button issue for a while, but it seems like things might be percolating now that we may not need meeting updates unless there's an issue. Okay. Well, gentlemen, you satisfied the committee. I think that we will not have you as a regular agenda item in the future, but we're always here if you have suggestions of what family court can do or how we can improve the system to make your lives easier in this regard. Please let us know. But thanks again for your service.
Thank you so much.
Thank you. And Jeff, best of luck with the wedding this weekend.
Thank you so much. Wishing you all the best for a wonderful weekend.
Absolutely. Take care. Speaking personally, that's a pleasant upgrade of the situation from where we were before and the amount of questions that was in the room from prior meetings. We do have lunch, but we're running about 30 minutes ahead of schedule, so I'd like to continue to just move down through the agenda and hopefully get people out of here early if that's all right with everyone. The next item for discussion on the agenda starts on page 28 of your materials. It addresses Rule 97. An administrative order that was issued by Chief Justice Timmer regarding Form 11. And while my name is next to this, I don't know if Judge Fisk would be willing to discuss the background of this and why this issue came up.
Sure. The issue came up because we were attending a CLE and one of the presenters mentioned the fact that the parenting coordinator form that was included in the rules had not been updated when Rule 97 was updated. So we had asked David Tasco if we could figure out how to fix the form. He did some sleuthing and determined that the form actually had been modified, but then when a subsequent rule petition was filed, it was inadvertently modified back to the old form. So what happened was someone's work in updating the form had been lost. We took the previously modified form, circulated it among a few parenting coordinators and judges for further suggestion. They made a few minor suggestions, which were submitted to the administrative director, Dave Byers. And he worked with Justice Timmer to have the new form, which is really the old form recirculated, adopted, and it is now part of the rules. Should conform to Rule 97 now, whereas it did, or Rule, I keep saying 97. I should be saying Rule 74. It should conform to Rule 74, but to the, and I would add that to the extent anyone sees that there are forms that don't conform to the rules, I think it is a great idea to bring those to this committee so that we can update those forms. There's no reason those shouldn't be updated. And in fact, I think it's confusing to litigants when they don't comply with the rules because they don't know what to do. And that's not fair to them. So to the extent anyone ever sees a form that doesn't conform to what they think the rule says, please bring it to the committee and do what we can to pretty expeditiously get it resolved. And thank you to David for all of your hard work on that.
Any questions or comments? I want to extend my thanks as well to David and also to the rest of the AOC staff who got this through legal and to the chief for signature and correction. It has been provided to Thomson Reuters, and so it will not update the current book, but in the book that comes out in January, we should have a correct form that complies with current statutory requirements and language. So thank you all. I've just left us standing. The next item on the agenda is the strategic agenda. I know most of this work is being done by work groups and we will cover it in the work group discussion, but I think it's always helpful to see when I present on the work the committee is doing. I always say we're guided by the strategic agenda, and that should be our focus in terms of moving things forward. So I like to include it there. Is there any discussion items that people have questions or concerns about that would be outside of a work? Judge Fisk?
I don't think we have a work group working on subsection G.
Correct.
And I just, this has become, well, one, we've talked about the fact that I think it, the intent was to allow juvenile court judges to issue bridge orders in family court cases, not family court judges. So that for those who don't know what I'm talking about, in subsection G, the last sentence says the commission should consider the need for a rule to allow family court judges to issue bridge orders. This continues to be an issue in Maricopa County, and we are continuing to discuss amongst ourselves what we can do to address this issue. But for those who don't know what I'm talking about, when a family is in juvenile court and they go to come to family court, one of the things that they may be told by the juvenile court is that you have to protect the child. And in order to demonstrate that you are protecting the child, you need to go file a case in family court. If you don't already have one, or if you do already have one but have no pending petition, you need to file a petition in family court. That process is incredibly onerous, especially for a self-represented litigant who is leaving the dependency system and coming over to family court. And I would really love to see a solution. I know that Pima County has a solution that they have that's a workable solution, but I don't know that every other county has that. And it continues to concern me. We continue to watch families struggle coming out of juvenile court, trying to get into family court. And they may not file a petition, or they may not file a motion for temporary orders, not understanding that a petition's not enough to just end up in front of the judge, but they're getting lost in the system. And these are our most vulnerable people. And I do not want them to get lost in this system. It's hard enough. And some of them, the juvenile judges, for good reason, are saying to them, you need to do what you can to protect your child. And they consider an indicia of protecting the child, getting that family court case filed and getting that case going. So I'll get off my soapbox.
No, it is an important soapbox. I know we had a discussion as a committee after Judge Bibbins presented from Pima County on the Pima County approach. My sense of the room was that the non-Maricopa and Pima counties didn't really have the same problem as much, just because of the size. That may be a misunderstanding of my point. I'm happy to form a work group on this. My question is, should we also involve the Committee on Juvenile Court potentially and do a joint work group between the two, because it really deals with both sides of that. And my only other thought off the top of my head was also it should probably be heavily populated by Maricopa County, because I think from what I hear in Pima County, generally speaking, Judge Burnett will correct me, I'm sure if I'm wrong, but our system may not be perfect, but it seems to work in almost all situations. And so we need to make sure there's flexibility for the counties to do what they want to do. But Judge Burnett and then Judge McCoy.
So the system in Pima County, it is functional, I will say. The problem of our most vulnerable people making it all the way over to family court, even when we have sort of hand fed it to them, is still a large problem. I would say the attendance rate at those hearings, once they're set, is best case scenario 50-50 or 50%. To me, what the problem appears to be is that they've gone through usually for obvious reasons, a difficult case through juvenile court and so forth that may have lasted quite some time. Sometimes they go into multiple years. And then we are asking them to head to family court to do additional litigation for a period of time. Oftentimes, and it's not really necessary, because what's happened in the juvenile case is that one parent has become sufficient and no longer a danger to the child, clearly should be the one making the decisions, but the other parent is not. And or if you're in the lucky case where both of them have managed to get out of it, there are things that I think our juvenile court judges could do. Now, the problem for juvenile court is that they are very, very busy, and family court legal decision-making and parenting time decisions require a very large number of findings. And the workload in trying to ask the juvenile court judges to make those types of findings in order to release a case with actual family court orders is problematic. And so my suggestion would be, yes, we definitely need the juvenile committee involved in this, because to me, it seems like the obvious answer somewhat becomes amending or creating, I don't know if it's it would probably have to be statutory, to be honest, but there needs to be a process where the juvenile court, who knows these families inside and out, has the ability at the end of it to say, you know, as the only parent that is rehabilitated at this point, you now have sole legal decision-making, you are the primary residential parent, and then designate the parenting time. Because in reality, there doesn't need to be another examination of the situation. There doesn't need to be further extensive findings. That's happened already in the juvenile court. And so that is the most obvious answer of getting them out, having actual orders in place, because I will tell you, one of the most nerve-wracking things that I have happen, even with our system in place, is when they do show up and one parent was not rehabilitated. It is very difficult to determine that at the family court hearing, because that parent's going to tell me DCS had no problems with me. They didn't enter any order saying I couldn't be around this kid, regardless of what those allegations might be. And sometimes, you know, with drug testing, I have some resources where I can try to get to the bottom of that. But, you know, if the allegation was about sexual abuse or inappropriate conduct of some sort in the past, those can be super difficult. Particularly in light of the fact that family court has very different goals and objectives than juvenile court. And so it's just my 2 cents. I know that's a massive goal and really a pretty giant ask, I know, because it's hard to get statutes enacted on that. But that does seem to be the route we ought to take, because there's no reason why a juvenile court judge couldn't enter that order. Right now, what's preventing it is the findings. It's the workload. They don't have the time to be able to do that, and that's why it's getting sent back to family court.
Thanks, Judge Burnett. And we have Judge McCoy and Judge Ainley. We'll take Judge McCoy first.
Right. And so I echo Judge Burnett in many a way. I agree that the juvenile court should be essentially passing a baton. They know this family inside and out. They know all of the allegations. They know who they have reunified to. And I think if we're looking at a statewide solution, it needs to definitely let the counties still do what they need to do within the counties, because this has so much been dealt with local rules, county to county. And I know that it is a larger county issue because I was the juvenile and the family court in most of my cases. And I could just tell myself what I did in that last case and then continue going. And I would ask them the permission to do a lot of different things because we in the smaller counties get to do that. I get to say, hey, you're sitting here, you have a family court case open, we're reunifying. This is the current terms. Are you agreeable to settling your case with these terms? I could do it today. You guys are done. And we can settle so many things as kind of I'm wearing both hats. And even in the cases where it was crossed between different judges, we have local rules that have us do that, where the juvenile court has the custody case, has to issue temporary or final orders in a custody case in order for it to be able to close out the dependency case. And so I do think that there's a lot of county to county practice that this will have to allow some freedom and focus much more on this reality of there's a judge out there who knows this case and really can't dismiss their case unless there are family court orders saying this parent is safe and this parent is not. Because I have those, I mean, currently in our court where you're reunifying to the parent who doesn't have custody. So you can't dismiss your dependency until the family court process is through. And our family court just sends it to the juvenile court. So I do think that it is county to county how you balance your caseloads. And if the juvenile court is given more judges so that they can do this portion, we can reallocate those resources and have those things completed.
Thanks, Judge McCoy. Judge Ainley, and then we'll have Leona.
The only thing I was thinking for the maybe larger counties where they don't have time is even if they could just issue the temporary orders and maybe transfer the case to the family court for further orders or findings. That's just an idea for some of the larger counties. Here, like Judge McCoy, the juvenile judge emails me. And it's difficult sometimes because I have to stay my case often until they finish their case, which affects our time limits. So there are a lot of reasons that it would be nice if the juvenile court could do more. It wouldn't necessarily have to be everything, though. So that's my 2 cents. Even if they could just do the temporary orders and tell the party, hey, you're going to have a court date in front of the family court so that they could get them there. That's a thought.
Thanks, Judge Ainley. I know my experience when I was on the family court, the problem with the temporary orders from juvenile court is that the parties wouldn't follow up. The case would get dismissed and then the temporary orders go away. And so that was.
It also assumes that there is a family case at that time. And so without one, you can't do a temporary order. You also have the issue of Title 25 is what governs legal decision-making and parenting time, which means you're subject to the findings. So even if the juvenile court had the resources and the officers to do it, the time commitment that's associated with making those findings is still potentially problematic. That's why I was sort of suggesting Title 8, if there was an allowance of some sort that would allow for them to enter that without being subject to the Title 25 findings, it would be helpful.
Well, we were talking about, we were talking about changing statutes and rules. So if the juvenile court had the ability to do temporary orders and set a new court date in the family court, then the parties would know about that. Perhaps they could show up. That's just my suggestion. But I mean, we could go full out as well and amend Title 8, but that's just my thought.
Thanks, Judge Ainley. And talking about legislative amendments, Leanna raises her hand.
Yeah, thank you. I just wanted to chime in and say that is something that I think I could get support for at the legislature. I think a lot of legislators are interested in getting these folks out of the court system as quickly and easily as possible, especially those cases that have been DCS involved. And so whatever we can do to speed up that transition, I think if we can run a good bill, we could have some legislative appetite. And I would certainly take it up with the legislators that are on the ad hoc joint family court committee, because I think that's a good solution. It gets people out of the court system and on their way, and they can just parent their kids.
Yeah, absolutely. Thanks, Leanna.
Yep. So to that end, if y'all want to start thinking about how you might construct that statute, I will send out our email request for legislative proposals for next session is coming out probably before the end of the week. So keep an eye out for that, and I'll make sure that David sends it on to your committee if you can come up with a good statutory change that will affect this. I think that would be a good legislative proposal for us to run next session if we can get all the sort of the statutory bugs worked out.
Awesome. Thank you. And yes, if you could forward that along to us, that would be great. Through staff. Judge McCoy again.
I just wanted to add, I do agree that the temporary order transition is a bit of a bridge from the juvenile court to the family court. And when I look at our DAP programs, which are the dependency avoidance programs, it's a mediation at the beginning of a dependency or immediately before a dependency is about to be filed to get family court orders in place. And I've always thought of that as so much more of a family court program, even though it is a juvenile court program, because it is taking people and sort of taking them out of the juvenile court, giving them a path into very quick family orders that are needed to be able to avoid that dependency. And I've been saying for a few years here that we need a reverse DAP, like essentially at the end of a juvenile court case, that bridge into family court. And I think that's essentially what we're talking about, is the juvenile court case is done to the degree that it's done, and it needs a family court to be able to close out. And so whatever we're able to construct to resolve that, I think that it is both of us, but I also think it very much could include those resources we have within juvenile courts that have mediations and sit downs and DCS in the room, and lots of things are done so that we can get family court orders expedited in that same DAP sort of a way. And I think that that could be very helpful as we move forward.
Thank you, Judge McCoy. Any additional discussion? Aaron Richardson.
Thank you very much, Your Honor. I apologize if I missed this at the beginning, but have we had any discussion about Family Rule 5.1 that contemplates simultaneous proceedings already? So I mean, but I don't know if that would be a place to start if we're looking at amending. There is at least precedent for and a presumption that the juvenile court would have time to look at legal decision making and parenting time.
Judge Burnett.
Yeah, because the case does get obviously taken over to some degree by the juvenile court and stuff. And so this does, just in listening to Judge Ainley and Judge McCoy and stuff, this does seem like to be a primary problem from Maricopa County and Pima County because of our size and the inability to get there. And so just to give you kind of an idea of what this might look like. So what we're really talking about are cases. I had a family that they were both deaf. They had 3 children, all deaf, that had been in a dependency for about 1.5 years. They managed to get out of it. The kids were placed with mom, but no orders came to me at any point telling me what's going to happen with dad. And there were pretty serious allegations. So what ended up having to happen is we had to go to a trial. We had to do the family law process, and it just extended it. Whereas I think if the judge at the end of the day, I mean, there weren't even, I think in that case, temporary orders. You could theoretically have some temporary orders in place that would hold it there. But then again, if things dismiss, the temporary orders dissolve. And so that's kind of what we're talking about. There are lots of systems that are working. We're doing things to transfer and get it there. It's extending the amount of time in which people that, and in that case, I cannot imagine how difficult it was for her to represent herself as a deaf person. I mean, obviously we had interpreters there as well, but it's hard for the average person, and to have these extra challenges and stuff, it's just not necessary. The juvenile court was clearly in a position where if they'd had the time and the ability to do so, could have entered a sole legal decision-making order for her and indicated that dad was to be supervised at all time, which is eventually where we got. So that's kind of what I was talking about in terms of it would be great to have some coordination there, because for our big counties, it is not feasible for juvenile judges to go make those findings. It's too time consuming, unfortunately.
Thank you. Well, and I think with Liana, if you're available, my question was, I think legislative proposals to make it through AJC and otherwise are late June, early July. At least last year it was early July.
I think our deadline is August 15th this year. It
Well, I
has
like
not
August.
gone out yet, but
Yeah,
it'll be
fair enough.
mid-August.
We like August a little bit better. It gives us a little bit more time over the holidays. I think it's in my discretion as chair to form work groups, so I'll form a work group on this issue the primary issue is let's see if we can propose some statutory language, to at least make the ball roll forward by that tentative August 15th deadline. Is there anyone, sounds like we may have some subject matter experts from various counties on this committee, but is there anyone wanting to serve or any suggestions? If you have people, again, with work groups, you do not have to be on it. Patricia wants to be on it. Okay.
I'll be on.
Okay.
I'd like to nominate someone.
Fair enough.
Not in the room, Judge Robert Brooks.
Okay.
And can I call you?
You can call me.
I've got a couple other people. I just don't want to.
Talk to them first.
Yeah.
Fair
But
enough.
he can do it, but.
Okay. Fair enough. And we will, Randy? Okay, Judge Burnett will be on it as well. Okay. Well, we will do it. We'll figure, once we know who's on it, we'll figure out who can chair it. We have someone raising their hand. Judge Ainley?
Yes,
Thank you,
I'd be
Judge.
happy to be on it and take any input from our Judge Young, who's our juvenile court judge here in Yavapai County as well.
Awesome. Thank you. Well, hopefully we can get some work product together. I agree. I think it's a very practical solution for moving forward. And if they can finish that task, maybe we can also ask that same group to look at item E a little bit more closely, the DCS records and access to juvenile court records, once there's not as much of the time pressure of getting through a proposed legislative amendment. Any additional discussion on the strategic agenda? Okay. I know we'll get reports from work groups that will touch almost every other issue. Judge Fisk, thanks for directing our attention again to that issue. I appreciate it. The next item on the agenda, and maybe our last item before lunch, because it looks like it may be here, will be summary consent judgments regarding maternity, paternity, child support issues. This was an issue that was discussed last year by the committee because we did have a statutory change that allowed parties who were divorcing to file a summary consent petition. But nothing was included to allow those people who are proceeding for parenting time, legal decision-making, paternity, maternity, and child support to file a similar sort of petition. And so what you see in your materials was a draft that I put together in connection with getting feedback from some other members of this committee, making a suggestion, one, that we propose a rule change that would allow for a summary consent decree proceeding in, again, what I'll call paternity, legal decision-making, parenting time, child support issues, but would also include a proposed statutory change, would include now 25-80601 would be a new statute that would allow for a summary consent petition process. The primary reason for the statute is that it would carry over the cost-saving benefits for parents so that they would only have to pay one filing fee rather than two filing fees, something that is in the summary consent decree process. We used the language of the existing rule and statute to carry it forward. The one change was because we do not have the waiting period associated with a paternity case to make the edits to that. So with a long wind-up, that's the background of what's in your materials. So, there any discussion? Yeah, Jenny.
Was there any thought of including third-party matters, like third-party visitation in this?
It was discussed amongst a small group of us. We chose not to include third-party matters. Doesn't mean that it couldn't be changed easily to include third-party matters. Judge Fisk?
My concern with third-party matters is the presumptions that exist under the law and the need to make certain findings. So it's not as clean as a paternity or dissolution matter.
The other proposed rule suggestion, I believe, is the one that's on the screen. Amending 45.1, there's been some issues that the trial courts have been experiencing in terms of this intent to withdraw what do you do when one party wants to withdraw? What do you do when both parties want to withdraw? And so this is sort of also a cleanup provision for that rule that would break it into two parts of what does the court do when one party intends to withdraw? What do you do when both parties intend to withdraw from the system? That's on page 41 of the materials. Additional discussion? Again, the process would be for the proposed statutory change, we would make the recommendation to the Arizona Judicial Council to see if they wanted to include it in our legislative packet. Sounds like the deadline for that will be mid-August. If the committee votes for it, I can take the lead with others' assistance in drafting the final request to AJC. For the rule change, it would be a rule petition to the Supreme Court that they would consider. Any adoption of it would be January of 27, I guess, unless we ask for sooner consideration of it. Since we have crickets in the room, it's either close to lunch or there's no opposition.
I would move to approve the legislative.
Okay.
Move to approve the legislative amendment.
And I'll second it. Oh, Michael did.
Okay, I think Michael beat you to the punch. So motion by Jenny Gatto, second by Judge Peterson to propose the adoption of what would be 25-80601. Any further discussion on the legislative side? Hearing none, is there any opposition to the motion? Hearing none, the motion carries. We'll take along the task. David, I'm sure will help out. Make sure that we submit that by the deadline so AJC can consider it in their fall meetings. Is there any motion related to the proposed rule change? Let's start on page 39.
I move to submit the petition as written.
Okay. Motion by Judge Sklar, second by Judge Peterson. Any additional discussion?
So that we're clear, that includes rules 14, 45, 45.1, and 45.2?
Correct.
Thank you.
And the cleanups to rules 14 and 45 was thanks to Judge Fisk, who noted that we should clarify language because the Court of Appeals is telling us they're applying the rules as written. And so, thank you, Jeff. We want to make sure that we want to make sure that that we address those issues. The 45.1 was the cleanup again about who's withdrawing and what do we do about it. And then rule 45.2 would be a new rule. We have a motion second. Any further discussion? Hearing none. Any opposition to the motion? Hearing no opposition, the motion carries. We'll work on submitting a rule change petition to amend rules 14, 45, 45.1, and propose the adoption of rule 45.2 as set forth in the materials. Thank you all. I think this would be great for families. Obviously, those parents who have agreements on all issues, it'll allow them to get their judgments and orders without having to go through the rest of the process and additional filing fees, hopefully, if the legislature were to agree. We're a little bit early, but I think it's time for lunch before we delve into the rules part of the agenda in our work group presentations. Is there anyone who's presenting on work groups that has time restraints this afternoon? I should have asked at the beginning of the meeting. Not hearing any. So how long of a break, David? For 1 hour? We'll take a 1 hour recess for lunch. It is now 11:35. So if we get everybody back 12:35. I'm 12:35. For those in the room, there is lunch being provided. If you could just please make your contribution. Any other housekeeping details, David?
That contribution is $5.
Thank you all. We'll stand at recess.
Recording stopped.